Hello, my name's Rodger Citron. I'm a professor at Toro Law Center. This is a Toro Law Review podcast, and we're delighted tonight to have as our guest Ashley Keller. He is, most significantly for tonight, counsel of record in a case recently argued in the United States Supreme Court and even more recently decided, the Mallory versus Norfolk Southern Railroad case involving personal jurisdiction. We're going to talk about that tonight. Thank you, Ashley, for joining us. And my first question, before we get into the Mallory case, of course, just tell us a little about yourself, please.
Sure. So it's a pleasure to be with you, Rodger. Thanks for having me on. It's a fun topic, so I'm excited to discuss it with you. So what can I say about myself? I'm the founder of Keller Postman, which is a firm that focuses on complex plaintiff side litigation. And perhaps unusually for a plaintiff's lawyer, I also have the distinction of being a proud conservative, a member of the Federalist Society. Those two things don't often intersect, and that might be a segue into sort of how I sort of landed into the Mallory case, where I was defending a plaintiff and his right to sue in a particular place in Philadelphia, while simultaneously making some arguments that sound in more conservative principles.
Yes, we'll certainly jump to Mallory. I just have to say for myself, I teach civil procedure, and the reason why I really wanted to do the podcast, and again, thank you for taking the time, is because when the decision came out, what a fascinating constellation to get to 5 votes, reversing the Pennsylvania Supreme Court. I'm sure we'll get into that. Tell us, how did you become involved in the Mallory case?
So by serendipity, I have worked very closely with my friend Frederick Longer on the Law and Briefing Committee in the Zantac MDL. And Fred's firm represented Robert Mallory in the trial court and then in the Pennsylvania Supreme Court. And I actually just saw a headline, like everybody else in Law 360, when the Pennsylvania Supreme Court issued its decision saying that Pennsylvania law violated the due process clause under modern precedent like Daimler and Goodyear. And when I saw counsel of record for the case and realized that it was Fred's firm that had represented him, I reached out to Fred and I said, hey, I think that this is a really interesting issue. I think you have a chance of getting this to the Supreme Court and getting the Pennsylvania Supreme Court judgment flipped. And I'd very humbly like to throw my hat in the ring, and I'll give you a really great rate. I'll do the case for $1. So Fred promptly paid me the $1 of consideration, and I was counsel of record for Mr. Mallory at the cert phase.
Really quick, before we sort of walk through the proceedings in the Supreme Court, what was going on in the Mallory case that you would have this issue about whether or not a Pennsylvania court had authority over the railroad, had jurisdictional authority over the railroad? Can you just, for those of us who haven't read the case cover to cover, why was there a personal jurisdiction issue in the case?
Yeah, so I'll give you the syllabus version of the facts. So Robert Mallory worked for many years for Norfolk Southern as a carman, and he alleges he was exposed to chemicals that caused him to get cancer. The allegations are that he was exposed to those chemicals primarily while he was working in Ohio. He did live in Pennsylvania for a number of years, but there is no allegation, and we on Mr. Mallory's side don't dispute that that's not where he was exposed, that's not where he was diagnosed. The relevant facts in terms of specific jurisdiction principles happen someplace else. Mr. Mallory retired and moved to Virginia and became a resident of Virginia. And that's when he discovered that he had cancer and sued his former employer. Norfolk Southern at the time was a Virginia company. And so you have a resident or a citizen of Virginia suing another citizen of Virginia. He filed his suit, of course, in Philadelphia in the Court of Common Pleas. And like I said, my friend Fred Longer and his partner Daniel Levin are Philadelphia lawyers. And actually an interesting feature of this case that doesn't really come up much in the opinion. He sued under federal law. It's a FELA case. And normally, if you sue in state court under a federal cause of action, the defendant, if they don't like the state venue, removes under federal question removal jurisdiction. But Congress decided over 100 years ago that in FELA actions, you can't remove based on federal question jurisdiction. So you'd have to remove, if at all, under a different head of jurisdiction. The most common one would be diversity, but diversity wasn't available here because you had two citizens from Virginia. So you had a person suing in Philadelphia when the relevant facts of his cancer diagnosis weren't connected to Pennsylvania. And so the railroad raised a personal jurisdiction challenge and said, this suit doesn't belong here, and allowing it to proceed here offends due process. There's no specific jurisdiction. The relevant facts happened in Ohio. There's no general jurisdiction because we are not incorporated. We, Norfolk Southern, are not incorporated in Pennsylvania, and we don't have our principal place of business here. And so there's no general jurisdiction either. We should be out of Philadelphia. And Mr. Mallory's response to that was, well, there is general jurisdiction here because you consented, Norfolk Southern, when you registered to do business as a foreign corporation operating in Pennsylvania. You filed a form registering your company, and Pennsylvania law is very clear that by registering to do business as a foreign company to operate within the Commonwealth, you are subject to the Commonwealth's court's jurisdiction for any suit under the sun. And so that was the argument Mr. Mallory raised. It was not successful in the trial court or the Pennsylvania Supreme Court. They both relied on cases like Daimler and Goodyear to say that general jurisdiction is only available where a company is quote unquote at home or incorporated. And the Supreme Court of the United States saw it differently. And so there's now a ruling 5-4 that there's no due process violation.
Yeah. And do you know whether the suit was filed, if I can ask, whether it was filed in Pennsylvania, in Philadelphia in particular, because of the fact that the statutory scheme in Pennsylvania says general jurisdiction under the circumstances that you described? Was that, how much of that was sort of thought about prior to you sort of becoming involved?
Yeah, so that decision predated me, but it was definitely thought about. This is not the first time that plaintiffs have relied on Pennsylvania law. And there's a Third Circuit case from the 1990s saying that Pennsylvania law is fine and it does create jurisdiction. Railroads like Norfolk Southern have previously chosen not to challenge the law. So this was a well-worn path that the plaintiff went down. It's not like they didn't think about it. They knew that this was going to be the basis for personal jurisdiction. The railroad just decided this is going to be the one where we take a shot at getting the law ruled unconstitutional. And I don't know tactically why they made that choice here, but maybe they thought enough law had developed and Daimler and Goodyear had set in, and now was the time to put an end to Pennsylvania's registration statute. But the plaintiff's lawyers, again, at Fred's firm, definitely thought about Pennsylvania law and knew that it was on the books before they filed suit in Philadelphia.
Mm-hmm. And then at the point when you became involved, thinking about the cert petition, your first task is to get at least 4 votes.
Yes.
And so how did you think about that in terms of crafting the cert petition? One of the things we traded emails, in setting up this discussion, and one of the things I noticed is your opening brief, not your opening brief, your cert petition itself, right, leads with, Justice Gorsuch's concurrence from the Ford case. And I'll stop there because, of course, you wrote that, and you should tell us, what you were thinking as you were doing that, please.
Well, exactly as you said, your first strategy is to get the court to take the case. And Rule 10 from the Supreme Court's rules kind of lays out the most common reasons that the Supreme Court will grant cert. It's not a surprise. They only hear, 60 or so cases a year now. So they're very choosy about the cases they select. And the ones that they tend to gravitate towards are ones where there's a split in authority, where either the federal courts of appeals, the state courts of last resort, or both disagree with each other about an important issue. And so the first thing that we kind of led with, we teased with Justice Gorsuch's concurrence, as you noted, in Ford, which was joined by Justice Thomas. So we wanted to make sure that we put front and center that this was an important issue. Personal jurisdiction doctrine has developed a lot since International Shoe, and it may have come a little bit unmoored from the original meaning of the Constitution. We wanted to make clear that we thought that that was an important aspect of the case. But a main part of our argument was the courts just disagree with each other. And so you, as the Supreme Court, are the only court that can provide harmony and uniformity to the law. And so we kind of did a march through all of the different courts that had come out in different ways on the constitutional validity of registration statutes like Pennsylvania's. Every court of appeals at the federal level has weighed in on this question and, came out different ways. Admittedly, a lot of the earlier courts of appeals decisions are the ones that went our way. And then, some of the later ones post Daimler and Goodyear started to go in a different direction. There were state courts of last resort that disagreed with each other within months of the Pennsylvania Supreme Court decision. A few months prior, the Georgia Supreme Court came out the other way in favor of the plaintiff based on Georgia's registration statute. There are various state Supreme Courts in addition to that that have sort of addressed the question. So we leaned very heavily into that disagreement between the state and federal courts to say, hey, U.S. Supreme Court, this is exactly the sort of case that under Rule 10 you say you want to take. And obviously the issue of what the Due Process Clause permits sovereign states to do is an important one. And you don't want to have some system where, whether you're in Georgia versus you're in Pennsylvania determines the constitutional propriety of the plaintiff filing suit. That's kind of a bizarre disagreement to allow to continue. So that's kind of the focus of the cert petition.
Yeah. And this may reflect, I've taught now for close to 20 years. When I go through civil procedure and do the personal jurisdiction material in the fall semester, I feel like, I think the case books tend to sort of look past the registration statutes. They certainly have to discuss them. There's no doubt about that. And I wonder whether, part of my interest in the case, part of my surprise about the decision, because I sort of thought, oh, well, general jurisdiction, it's settled after Daimler and Goodyear. I wonder whether that just reflects my own sort of absence, the fact that I don't practice and I'm not aware of how significant registration statutes are. Is there sort of, I guess this is, I'm sort of talking about my own ignorance, and I'm just, and I'm wondering why, like, how did I miss the importance of registration statutes? Because one of the things that you absolutely did in the cert petition was, oh, this has been extensively litigated. Circuits, state courts. There's different statutes, there's different decisions, and so on. And so, I guess maybe the question I'm trying to ask is, did you have a sense before you sort of dug into this that the registration statutes are an important, even vital part of, the exercise of jurisdictional authority, personal jurisdiction authority?
Yeah, so I got the same sort of march through the case law when I was in law school as how you teach it, and registration statutes were kind of an afterthought or a footnote. And I'll admit as well, maybe I'm right there in the ivory tower with you. I had not focused in my practice on registration statutes. And until I saw the Pennsylvania Supreme Court and the Georgia Supreme Court decisions, I didn't even know that these were a thing. So it was Mallory that caused me to look at all of the history. And part of the reason you don't see as much of these registration statutes in recent times is because cases like Daimler, Goodyear, and starting with International Shoe started to make them, I won't say obsolete, but less necessary in the eyes of many legislatures, and then courts started to narrow their registration statutes based on canons of constitutional avoidance. And so Pennsylvania really stands out as one of the states that has a super clear registration statute. It's beyond doubt that you're consenting to the jurisdiction of the Commonwealth's courts. The language doesn't leave any room for ambiguity. I think some of the older statutes talk about appointing an agent to accept service of process, which back in the 1800s, there wasn't any doubt what that meant either. But with modern gloss and modern eyes in a post-international shoe world, you could say that those statutes don't do the same thing as consent to jurisdiction. Pennsylvania law doesn't leave any room for ambiguity. So it kind of, as I said at oral argument to the court, stands alone today. But back in the 1800s, it was not alone at all. It was ubiquitous to have statutes like this. And that's something that I learned thanks to Mr. Mallory.
Yeah, yeah. And then I guess this would actually, I mean, the sort of the continuation of cert was granted. And then, of course, there's the merits briefing. And one of the things I noticed in reading the briefs in the case was that my impression was that in the merits briefing, you really pushed, sort of the forefront, the idea of original public meaning sort of supplies the answer. And that certainly was in the cert petition, but it seemed to move up, as sort of your Roman numeral one or your argument one in the merits brief. And can you say a little bit about,
Yeah.
The tactic or strategy, your thought as you were like, well, now we know we've got a case, we've got an argument and a merits brief.
Yeah. So the strategy is hopefully not all that mysterious. I didn't want to be accused of sandbagging, so I definitely mentioned the original meaning of the Constitution in the cert petition, but I also didn't want to give very able counsel for the other side, Carter Phillips, who has argued more cases than I think any person in private practice, all of our great arguments up front. And so I deliberately didn't put it in the cert petition because the cert petition's not about the merits. The cert petition's about why there's a disagreement or why there's some important question that you, the Supreme Court, ought to take up. And I saved all of that originalist firepower for the merits brief. Why did I lead with the original public meaning? I think two answers. One, I am someone who cares a lot about the original meaning of the Constitution, and I'm a more or less FedSoc type of person in my disposition. And I think that if the original meaning dictates an answer, all things being equal, that ought to be the rule of decision for the case. And the second thing is more practical as opposed to based on first principles. There are a bunch of justices who have been nominated by presidents and confirmed by the Senate who sit on the Supreme Court who purport to care about the original meaning of the Constitution. And we've seen recent decisions in areas like the Second Amendment and the substantive due process clause that lean very heavily on the original public meaning. And so I wanted to make sure that I spoke to those justices and said, hey, even if you're politically conservative, which might not line up with finding in favor of a plaintiff, the fact of the matter is your job is not to be a politician. Your job is to be an interpreter, an expositor of what the law is. And the primary methodology that you claim to buy into to interpret the Constitution says that my guy wins. And I wasn't going to leave that on the cutting room floor. I was going to make sure to lean heavily into originalism and show why in 1868, there's really no doubt that sovereign states had the ability to pass laws like these.
And this goes to, I sent you that short piece that I wrote with my colleague. And of course, I was sort of, I was someone who thought, oh, well, again, Goodyear and Daimler, this court, the Roberts Court in particular, has narrowed the availability of general personal jurisdiction. On the other hand, and really I commend my colleague, Professor Dooley, because, she paid more attention to the Ford Motor case, the fact that, and when I look back, right, Gorsuch concurred, Thomas joined that, and then Alito also concurred. And
Yeah.
so, when
And
you were
said
talking,
nice things about Gorsuch's opinion.
yes, yes. Um, but then I sort of have to ask, Ford Motor Company, like if we roll back to, prior to the oral argument, say, still the trend of decisions, even though Ford, upheld the exercise of personal jurisdiction, overall under the Roberts courts tended to be either restrictive or narrow in the availability of personal jurisdiction or rejecting the exercise of personal jurisdiction. So I guess there's sort of two things. One is, how did you think about the two justices um, who didn't participate in Ford? I believe, right?
Barrett
Justice,
and Jackson.
yes, right. Barrett, I think, I didn't participate. And of course, Jackson was, I think, appointed and confirmed subsequent to Ford. How did you think about them and where they might line up? Um,
Yeah. So I was obviously hopeful that I would get both of them, and I split the baby and got one of them. Um, Barrett, I thought I had a shot at her based on original public meaning, and Jackson based on things like perhaps original public meaning, but also Justice Brennan's concurring opinion in Burnham and sort of the policy and fair play and substantial justice. There's really nothing unfair about holding a big Fortune 100 company to the waiver that it voluntarily chose to enter into. And this notion that that's a Hobson's choice or a gun to the corporation's head, that I could see that not rubbing her the right way. And fortunately it didn't. But yeah, I was sort of looking at the Ford case as something that gave me hope that we could get to 5. And I noticed the same things you do about, Gorsuch, Thomas, and Alito writing separate opinions. And I'll also say it's a good reminder that the Supreme Court, even though it's the Supreme Court and it's announcing rules that are important and will have precedential effect in the lower courts and the state courts across a wide swath of cases, it's still a court that decides individual cases and controversies. And the arguments that the litigants choose to make or not make to the court are important. And you can't expect the court to consider the original public meaning of the 14th Amendment if you don't ask them to. And so if you just write a conventional brief that says, here's what the precedent says, and if you squint at it carefully enough, it tells you the rule of decision. In this case, that's fine. And you can win or you can lose based on that strategy. But if you want the court to try and go back to 1868 and say, here's what the Constitution meant back then, you have to ask them. You have to ask them to do it, and you have to back up your ask with historical evidence. So if you're going to ask the court to be originalist, you have to deploy an originalist methodology. And so I'm on my soapbox for originalism
yes.
and telling my fellow plaintiffs lawyers, we can win a lot of plaintiffs' issues that are important to us, but it's not going to work if you don't make the ask. You have to do the homework. You have to present a cogent argument, and you have to actually grapple with originalism as a methodology.
And this is a little bit of a segue, but I feel like it's relevant because the Supreme Court decision, I guess it was last summer in Bruin, I think the
Yeah.
Second Amendment case, it's extensively historical, if I can use that phrasing. Did you either in researching in the brief and writing the brief, did you find that doing that kind of historical legwork is it in any way notably or materially different than the kind of work you would do than legal research? And I guess buried in the question is, there was this discussion in Bruin about, well, at least in certain cases, you're going to have to be a historian as well as a lawyer, or you're going to have a graduate degree in history. And having sort of gone through and done the exercise in this context, if you could speak a little bit about uh, the task of doing the historical research and sort of sifting through that and how that compared to, say, writing briefs and cases, legal,
Yeah.
where you're looking at just sort of, cases and legal arguments and so on. I realize you were looking at lots and lots of cases, but I just there's a
Yeah,
question in
and look,
there.
that's one of the fair critiques of originalism. Office professor history, and it's asking lawyers to be PhDs in history when that's obviously not the discipline they went into. And I respectfully disagree with that critique. It's still about writing a cogent argument. You're still putting together prose that's hopefully going to be gripping and persuasive. And the purpose of going to the original public meaning of a constitutional provision and the method of doing that is not the same thing as being a PhD historian. You're trying to understand what words meant at a particular moment in time. It's no different than trying to figure out what a 10-year-old contract means. It's what the parties understood those words to mean when they entered into the binding agreement. And looking at historical evidence can help you disambiguate certain words. And I think we'd all agree our Constitution has some things that are black and white that don't require a lot of historical analysis. The president has to be 35 years old. We know what 35 means. It means the same thing as it meant in 1789. We can be done with that historical question. The words due process of law, if you just take some willy-nilly approach to it, or your abstract notions of fairness, you could drive a truck through it and come up with any rule of decision. And originalism kind of rejects that and says, we don't want these philosopher kings who are appointed for life to just be making up whatever they think the words due process mean to reach an outcome that they think is quote unquote fair for a particular case. We want to ground it in something. And if you've got a long-standing series of historical practices that are contemporaneous with the words due process of law being put into the Constitution that say states were doing what we were talking about in Mr. Mallory routinely, that's just really good evidence that the words due process of law don't stop the states from doing that. That's all it is. So I don't think that I had to change professions to write this brief compared to any other brief that I would write. I think it's just applying statutory canons, rules of decision, all the things that we are taught to be rigorous about in law school in a different context.
Yeah. And then we talked about the two justices who didn't participate in Ford. And then there's Justice Alito, who, of course, you got his vote this time on the due process issue. The Dormant Commerce Clause, I'll sort of ask the question. Anyone who reads the decision will see that there's a concurrence by Justice Alito where he brings up the Dormant Commerce Clause, which was part of the oral argument. Not much, but some.
Yep,
There were certainly substantive questions about the Dormant Commerce Clause. And the first question, where did that come from? That is the idea of the Dormant Commerce Clause in the context of Mallory. And then again, the second question, I'm sorry, I'm going to ask them both, is did you anticipate, or Justice Alito sort of latching on to that issue? If you could talk a little bit about how the Dormant Commerce Clause played out in your experience at the court, and then your thoughts about Justice Alito being sort of the proponent of that's next here.
Yeah, I'll take the second question first. I did not anticipate Justice Alito writing a concurrence that would then talk about the Dormant Commerce Clause. If I'm being completely honest with you and your students or whomever, I didn't necessarily think Alito was my most likely fifth vote. And after oral argument, I thought I had a chance at him, but it was more remote. I was banking on, if I could, I wasn't even banking on anything, but I would have ranked it as more likely that I would have gotten Justice Barrett, who obviously wrote the dissent, so I never had her. But I thought it was more likely I would get Justice Barrett than I would Justice Alito. He asked me a couple of tough questions and made a joke at my expense, saying something to the effect of, are there any natural persons who can be present at the same time in all 50 states? And I, of course, said no. And that got a chuckle. So I didn't necessarily think that I had him at all. it is interesting that he brought up the Dormant Commerce Clause. It's interesting that he notes that it has been widely criticized, and so I'll take 10 seconds here to criticize it. There is no Dormant Commerce Clause as an original matter. It is a figment of Daniel Webster's and Chief Justice Marshall's wild imagination. And even if there were a Dormant Commerce Clause, it would not be what is current doctrine under Pike's balancing, where we, weigh this versus weigh that. The idea of a Dormant Commerce Clause that was originally talked about but never embraced was that Congress's power over commerce is exclusive, and the states can't exercise their native jurisdiction over commerce at all, which might have made sense when commerce was also given its original meaning, but it makes no sense in a Wickard versus Filburn world where states would have no sovereignty at all if you said that federal commerce power was exclusive. So I could criticize the Dormant Commerce Clause for quite some time, and you can be rest assured if the case goes back to the Supreme Court, I am going to criticize it further and talk about the original public meaning of the Constitution again and how Article 1, Section 8 gives Congress affirmative power to act. There's no dormant state of the Commerce Clause that then has preemptive effect. But putting that to one side, the reason I think Justice Alito raised this is because there are some older cases, and look, I'm the first to rely on older cases, right? My stare decisis section of the brief was Pennsylvania Fire, which is a 1917 case from Justice Holmes. There are some older cases that find, as applied, some registration statutes like Pennsylvania's a violation of the Negative Commerce Clause. There are other cases that uphold them. So these cases start in the 19-teens, they run through the 1930s, and then you really don't see these registration statutes challenged under the Dormant Commerce Clause at all post-international shoe because of the regime shift that case creates. And then we have modern doctrine. It's interesting to me, and I'm reading tea leaves here, but Justice Alito is the only justice who makes any substantive comments about the Dormant Commerce Clause. The other four in the majority just drop a footnote saying this wasn't part of the question presented, so it's for remand, period. And the dissent doesn't say anything about it at all. The reason I think that might be interesting is we had another big Dormant Commerce Clause case this term, the pork producers case that dealt with California's right to say that you can't sell pork on California grocery shelves if the animal wasn't raised in a humane way. That was challenged under the Dormant Commerce Clause, and in another fractured opinion with a strange lineup of justices, the challenge was rejected. You had Barrett, Gorsuch, Thomas writing a main plurality, and then they were joined in their judgment by Kagan and Sotomayor. And then you have Jackson on the more progressive side, dissenting with the Chief Justice, Justice Alito and Justice Kavanaugh. So another weird 5-4 lineup there. And I think under pork producers, putting aside my originalist argument, Justice Alito's musings, and I don't say musings in a pejorative way, he said he was only talking about things that might prevail on remand, and he wasn't prejudging it. But his musings about the Dormant Commerce Clause, I think they would have a tough time standing up to the pork producers case.
It kept sticking out to me, the 1923 case that I think is in the Alito opinion on the Dormant Commerce Clause in this context.
Davis.
Yes.
Davis versus Farmers Co-op.
And it seems to me that, when you're back in Pennsylvania, that will be, prominently part of the railroad's brief in opposition. Do you care to elaborate on anything that you've said here?
Sure. I'll give you the same answer I gave Justice Alito at oral argument. That way, I'm not giving anything away to Norfolk Southern. I'm just talking about things I've already said in the public record. There is that case, the Davis case. It's a very short opinion. Another very short opinion is the Turk case from 1932. So it's obviously subsequent Supreme Court authority. It also involves a railroad. And it says that where the railroad has filed the necessary paperwork, that statute doesn't violate the Dormant Commerce Clause. What are the distinctions between Davis and the Turt case? Honestly, I'm not 100% sure. They're both pretty short and they don't explain exactly why there is or there isn't a violation. But one fact that is, I think, particularly relevant is Davis notes that the railroad that was sued under the registration statute in that case didn't actually own the line, didn't own the track. And the railroad in Turt did own the track. Norfolk Southern owns its track in Pennsylvania. So to the extent that's the distinction that the court was latching onto when the Dormant Commerce Clause was just taking shape and it didn't completely mirror modern doctrine, that distinction could be the one that's dispositive. I'll also note, which I didn't at oral argument because it wasn't necessary, Pennsylvania's registration statute, I think, was designed knowing that there were some of those older dormant commerce cases, and it only requires foreign corporations that do intrastate business to register. So I think the legislature of Pennsylvania had the Dormant Commerce Clause in mind when they modernized their registration statute.
Well, we may at the end circle back very quickly to the Dormant Commerce Clause, but let's stay with the Mallory case that was argued and decided. The oral argument, any surprises? And I ask partly because I thought the case was very well argued, and I kind of thought the range of questions was generally foreseeable. I thought it really seemed to be that, there was a lot of they were really digging in on the case and the issues raised by the case. Maybe that's always what it's like with the oral argument in the Supreme Court. That's just kind of my, quasi-lay impression from what I saw. That is, was there anything that surprised you in the oral argument, either that you were asked or that your the other counsel in the case were asked?
It was generally in keeping with what I thought was coming. I did a bunch of moots and obviously prepared a lot because I was nervous and I didn't want to face plant in front of the Supreme Court of the United States. I will say, just from my own perspective, and this could just be me revealing my shortcomings as a lawyer, I thought this was a really hard case. The original meaning of the Due Process Clause, I didn't think was particularly hard. I think we had the better of that argument, and I'll stand to my briefs, Rodger, as to why that's so. But all of the doctrinal moving parts here between the Dormant Commerce Clause, the unconstitutional conditions doctrine, the policy ramifications. What do you do if you're in Justice Brennan's camp and you care about notions of fair play and substantial justice? What does international shoe take away from the Pennoyer era, and what does it leave behind? I thought all of that was really tricky, and I did my best to prepare for the questions that did come. And you're right, they came, and I don't think it was a surprise that they came, but I think it was tough. And you notice in both the majority and the dissenting opinion, some of those issues that came up at oral argument are not mentioned in the opinions, in part, I think, because they're tough and the justices decided, if we don't have to address some thorny doctrinal point, we don't want to do it, and potentially, muse about an area of law that's tricky. But I found it to be compared to, the Supreme Court only hears hard cases, so it's not some brilliant observation to say that the court was hearing a hard case, but I thought it was a hard case.
I'm struck by, when I teach the personal jurisdiction cases, how fact-bound the cases are. It really is like a quintessential or classic common law body of law, where you really sort of develop, the cases unfold in common law fashion. And when I was talking to my colleague, Professor Dooley, for that short piece that we wrote, I thought, well, on the one hand, Norfolk Southern does a lot of business. Like, it's very present in the state, and there's just great facts about employees and operations and the miles of track.
And Gorsuch puts that beautiful flyer in his opinion where
Did
Norfolk Southern brags about all of those points of contact with Pennsylvania.
part of the community. The and yet there was part of me, going back to, well, but it was like, but they're a railroad. What choice do they have? And again, I probably fall closer to the Jackson line about it's going to take a lot to persuade me that a corporation was, coerced here. Nonetheless, the fact that they are, involved in interstate transportation, what, how much choice did they have about could they really not run through Pennsylvania?
Yeah,
Go ahead.
good question. And Carter wisely brought that up a couple of times at oral argument. I'll say two things about that. First of all, I do not think that Congress has the ability to force a private business to stay in business, but we can put a pin in that because I think lots of things that doctrinally Congress can do under precedent. So let's just take for granted that Norfolk Southern can be forced to continue in interstate commerce. This is where the intrastate part of the Pennsylvania statute that I mentioned to you before, I think comes back into play. Congress could force Norfolk Southern under current doctrine and under the statutes to continue to run interstate business, but they didn't have to expand their footprint to have intrastate operations in Pennsylvania. So they didn't have to have all of the things that went in Justice Gorsuch's flyer about their involvement in the community. That's a choice. And then we're back to the coercion point that Justice Jackson and you and others, I think, latched onto, which is, yeah, you might have preferred to do business without any strings attached, but this was not a gun pointed to your head. Pennsylvania is not a mugger on the street lifting you of your wallet. This is you, making a choice that, albeit difficult, is one that you chose to accept in order to do the intrastate business in Pennsylvania's market.
Mm-hmm. Maybe one or two, questions before we adjourn. We sort of touched on it already. Was there the case, of course, was decided as a 4-4-1 along the lines we've discussed, with this very, interesting lineup of justices on both sides. Can I just ask as kind of, leading us to conclusion, anything about the decision surprise you? How each decision was written, who the authors were? I just go ahead.
So not surprising with the full benefit of hindsight, but at the time that the decision came out, Justice Gorsuch authoring it was very surprising. And to get into the nerdy weeds about it, I'll tell you why. The justices have a convention. It's not a rule, obviously, but it's a convention that they try and divide up the majority opinions evenly by sitting. And so if you look at the November sitting that Mallory was argued as a part of, by the time June 27th rolled around, Justice Gorsuch had already written a decision, a previous 5-4 decision from that sitting. And so I thought in my mind he was off the chessboard. And a couple of days before, Justice Thomas, Justice Barrett both wrote majority opinions. And so if you thought that the chief was keeping the affirmative action cases, which is what I thought and what a lot of people speculated, and then it obviously turned out to be true, it looked like Justice Alito was the only justice left, or Justice Kavanaugh, to write, that would need to write a majority opinion. And Justice Kavanaugh had previously written a bunch of opinions from different sittings that I think brought his total to 7. And if you do the math on the total number of cases for the term, he was basically done. It was pretty likely that he was done because otherwise he would have had 8 when somebody had 6. So I thought at that point, Justice Alito is very likely the author of the lead opinion in Mallory. And then obviously it came out with Justice Gorsuch. So that was surprising to me on the day it happened. The way that convention, as opposed to rule, is not followed is when you have a changed vote, a busted majority, maybe Alito was assigned the opinion and he wanted to say a lot about the Dormant Commerce Clause and the other four wouldn't go along with it. So it had to become a concurrence and judgment in part. Maybe he was originally with Barrett and the other three dissenters. And after he read what Gorsuch wrote in dissent, he said, you know what, I agree with my colleague, Justice Gorsuch, and I'm switching. I don't know what happened, but something happened for Justice Gorsuch to get two opinions from the November sitting. And so it was definitely a tough path to five. And I may have, gotten the necessary fifth vote pretty late, which is why, Norfolk Southern was argued November, I want to say November 8th, and we didn't get the opinion until June 27th. That is late. The affirmative action opinion's coming late. No one's surprised by that. One of the most hotly contested cases of the term. Obviously, it has, significant repercussions. Everybody was covering it. It's a big deal. I think Mallory's a big deal too. Everybody thinks their case is a big deal, but I don't think anybody, myself included, predicted Mallory was going to go so late in the term. And the reason could very well be a vote switched and you had to change a dissent to a majority or a concurrence to a majority or something like that.
Mm-hmm. Yeah, and I was, there was another civil procedure case that I think was argued well after Mallory. This was the one about, it was a much more sort of focused issue about do you have to renew the purely legal issue?
Oh yeah, that's a fun case. I liked that case, but yeah, it was argued well after and decided
well before. Yeah, and so it is intriguing, and who knows? Perhaps I don't know. Maybe one of my students, when they're a civil procedure professor, can look at the Library of Congress in 2016.
When they release their papers after Alito retires in 20 years, and 20 years after that, maybe we'll find out. But
yeah, and then the anything else about the opinion that you'd like to note?
I'm not really surprised with the opinion, and I'm not surprised with the lineup, other than, as I told you, Alito, I would have, in my own mind, maybe swapped Barrett as more likely to be on my side, but I definitely thought I had a shot at Alito. So if I was going to win, the 4 plus Alito was not a crazy scenario in my mind. Maybe a little bit of a surprise is that they relied so heavily on Pennsylvania Fire and didn't also get into a lot of the originalist details that I think would have supported Mr. Mallory also. But I think part of that is because of the weird political lineup, right? You're not going to get Justices Jackson and Sotomayor to sign on to an originalist magnum opus from Justice Gorsuch. And so when you have only 5 votes and you don't have anything to spare, sometimes you have to pick your spots as to what you can talk about, and to keep the coalition together. The opinion was what it was. So not really surprising to me.
Mm-hmm. And then there was at one point in oral argument, in fact, the way we talked about it tonight, I think, is almost exactly how you talked about it in a back and forth at the oral argument about the Dormant Commerce Clause. And I think I listened to, I didn't read the transcript, I listened to the oral argument. And so I don't know whether you said it to Justice Kagan or someone else, but the question is, so, will you be involved in the Pennsylvania briefing on the Dormant Commerce Clause? And I know that I just love the way you said it, that I'll be back. I'm paraphrasing, but it was succinct. And
I remember that exchange, and it was actually Justice Sotomayor. I think I was getting interrogated by Kavanaugh, who was not having any of my argument. And I said something to the effect of, the Dormant Commerce Clause is for remand. And she said, and you could hardly hear this, but I obviously was close and I could hear her saying it, "You'll be back up here if you lose." And I said, yeah, I'll be filing for cert if we lose below. Which I would be, but we're not going to lose in the Pennsylvania Supreme Court. We're going to win.
But you'll be participating, as an advocate, as a lawyer, as Mr. Mallory's lawyer in Pennsylvania. That's really because since you didn't come on until after Pennsylvania, I'm just curious if you'll still be involved.
My plan is to win this for him all the way. And so since there's an issue left on remand, maybe I'll negotiate a second dollar out of Fred and Daniel, but I plan to see this one through to conclusion, good, bad, or ugly.
All right. Well, that's the perfect place to conclude. Really, thank you so much for walking us through the case and for taking the time to talk to the Toro Law Review on this podcast. I think we're done here. Thank you.
My pleasure. It's good to meet you.